Greetings. Welcome to the final speaker in this semester's colloquium on inequality, human rights, and labor. I just wanted to say, so our speaker this afternoon is Alvaro Santos with a response from Willie Forbath. And before I introduce Alvaro, I just wanted to say thanks to a few people who have helped make this semester possible. So most importantly, the students in the seminar, and so that you know, Alvaro, they're mostly in this table, and most of that table, and some of that table, and one over there. And they will, they'll have the opportunity to ask the first questions after the comments today. But thanks to them for engaging not only in the public sessions we've had, but with each of the speakers' work for at least a good week before they get here, and for all the terrific engagement that you all have had with each other. So it's not the end, this isn't the last time we'll see you all, but it's been, I just wanted to thank you for being obviously the important part of the audience, one of the important parts of the audience. And secondly, I'd like to thank those of you who have come to, well, who are here today, but also a number of you have come quite regularly and have watched the colloquium unfold, and that's been terrific to see you all here regularly. I also want to thank Kate Taylor, who is always sitting, no, you're not always sitting back there, but you're sitting back there today, who has helped coordinate and organize the course and select readings and been involved with the speakers and just been integral to the seminar, and great help with the research on student papers, and we're hosting a mini conference in the next couple of weeks with them and looking forward to that. And to Sarah Klein, who is back there, who has been responsible for feeding us all every week, but more importantly for getting the speakers here and finding them places to stay, and all of the background work that takes place that is not visible but obviously essential. And I also want to thank human rights scholars and interns at the Rapoport Center, and maybe you can just raise your hand if you fall into that category. So they've been involved in the publicity, in writing up summaries of the talks afterward, and just a special thanks to Mia Hanwango, who has been in everybody's face with the camera and getting terrific pictures, and we appreciate that, so part of the documentation. And then finally to Billy Chandler for kind of making sure that all of that other stuff being behind everything I just said. Anyway, I really appreciate it. It has been a terrific semester, and the bar is very high for you, Alvaro, but we saved you till last because we know you can meet it by leaps and bounds. So Alvaro Santos is professor of law and also director of the Center for the Advancement of the Rule of Law in the Americas at Georgetown University Law Center. He has a very impressive resume, but the most important part of it is that he taught at UT Law School from 2005 to 2007. We miss him, but have managed to get him to come back regularly, maybe not regularly enough, but fairly regularly from DC. And in fact, he spoke at the very first Rapoport Center conference we ever had in 2005. So he's been a part of this place and our work, and we're hoping to continue to do some work maybe together with the center that he's just begun to direct. Alvaro teaches and writes in the areas of international trade, trade law and economic development, drug policy a little bit, transnational labor law, and the future of NAFTA. And I don't know if your resume always said the future of NAFTA or if that's a new addition. We might hear a bit about that. He's the author of many articles, a number of articles and book chapters, and he's co-edited 2 books on law and development, one being The Law in the New Developmental State, the Brazilian Experience in Latin America, and the other, The New Law and Economic Development, a Critical Appraisal, the first from 2013 and the second 2006 Cambridge University Press, and I think it's about time for a new law and economic development forthcoming. So the title of his talk today is well, the talk was The Future of Labor Rights in Trade Agreements, and it draws from this draft paper, which adds lessons from the TPP and something specifically about labor chapters. The students in the class read it last week, and some of you have asked for it and maybe had a chance to look at it, and we're looking forward to hearing it presented. After Alvaro speaks for 30 to 40 minutes, we will hear from our own William Forbath, who is Lloyd Bentsen Chair in Law and also Associate Dean for Research here at the law school. He's a legal and constitutional historian, and much of his research focuses on economic and social rights, labor rights, and constitutional political economy, and much of that is done in comparative perspective. And so he is an ideal person to beef up on his trade knowledge and respond more broadly in the political economy realm to Alvaro's paper. So please join me in welcoming Alvaro Santos.
Thank you. Well, it's a real pleasure to be here. Thank you, Karen, for inviting me to present in this workshop. Thank you to the Rapoport Center people for inviting me and organizing my visit. Thanks to William Forbath for agreeing to comment on my paper. As Karen mentioned, I started my academic career here at UT, and so I'm really fond of the school and of the city, and it's great to be back. Thank you all for coming. So my talk and paper is titled The Lessons of TPP and the Future of Labor Chapters in Trade Agreements, and this project is part of a research project called Mega Regional Ordering Projects After TPP, organized by the Institute for International Law and Justice at NYU. So let me say a few things first about the TPP. So the Trans-Pacific Partnership is a trade agreement between 12 countries situated on both sides of the Pacific Ocean, which represented close to 40% of the world's GDP, and it's a mix of rich countries and of developing countries. You have them there on the slide. For a while, it seemed like mega regional agreements like TPP or like TTIP, the Transatlantic Trade and Investment Partnership between the EU and the United States, was where the action lied, that somehow the global architecture was being designed not at the multilateral level in the WTO, but at the mega regional level in agreements like this. And so there was a lot of expectation about this agreement and what was going to happen with it. And when I started this project, one puzzle that I wanted to figure out was why, despite having the most robust labor chapter ever included in a preferential trade agreement, the labor movement in the United States was so adamantly opposed to it. And so one possible answer is that TPP represented the continuation of the liberal globalization agenda as we knew it, which workers felt had not really benefited them. And this relates to what we've seen in these last couple of years as a backlash in industrialized countries against this model of globalization, very much focused on trade agreements like this. We saw the UK's decision to leave the European Union and the election of Donald Trump in the United States with a very anti-trade campaign. But I think it's also important to remember that it wasn't just Donald Trump and the Republican Party, that the two final contenders of the Democratic Party, Bernie Sanders and Hillary Clinton, also adopted an anti-TPP and anti-trade agenda. So that there was also important discontent generally that was being channeled or directed against trade agreements and this model of globalization. And so as this debate unfolds, two positions that I see becoming dominant are, on the one hand, a backlash against globalization represented by America First policy and the retrenchment to economic nationalism. And on the other hand, the continuation of liberal globalization as we know it, perhaps softened up and with an insistence to better explain the benefits that they yield to societies. So the big question now that animates this paper, but also my ongoing research, is can we use this moment to reimagine the global economic architecture? The US has been a leader and a cheerleader of trade liberalization in this fashion. And so now that the Trump administration has so forcefully challenged this model, is there room for rethinking what the legal and institutional architecture could be? And more specifically, what would that mean for advancing the interests of workers in the rich countries and in the developing world alike? And so to bring these questions back to my presentation, what role does the TPP can play in this, and what can we learn from that experience? One initial remark is that the 11 remaining parties of the agreement have recently announced that they plan to continue with the agreement without the United States, and that whether they succeed in doing that remains to be seen, but so there's a possibility that this would actually become a valid agreement. And the other point is that even if this agreement doesn't enter into force, it still remains the latest example of a mega-regional negotiation, and the rules that were agreed on still serve as a point of reference for other negotiations, for instance, the NAFTA renegotiation, and that countries are drawing on those rules, and it stands as a mode of governance that can influence and serve as example for other future free trade agreements. And so I think that that's why TPP continues to be relevant. And so with those initial questions in mind, I'm going to divide my presentation in 3 parts. First, I'm going to talk about the TPP labor chapter and its critiques. Second, I'm going to look at other aspects of the trade agreement that could be of interest to labor, and in fact were pointed out by labor advocates in the United States as really crucial. And third, I'm going to look at other policy domains, both at the international and domestic level, that we might want to look at if we're interested in improving the lot of workers under conditions of globalization. And so before I move to that, let me just put here a slide on the different aspects of the TPP that were announced or declared as innovations of TPP in contrast to past free trade agreements. So the labor chapter, which I'm going to talk about, and environmental standards, digital trade, stronger IP protections, a carve-out for the chapter on investment pertaining to tobacco control regulations, a regulation on small and medium enterprises, chapter on and more stringent standards on state-owned enterprises, a chapter on development and capacity building, provisions on transparency and anti-corruption, and also a joint declaration on currency manipulation. So TPP was thought of and very much announced by the governments that were participating as the gold standard of a free trade agreement, and as an agreement that had proposed and further expanded trade liberalization in these different areas. Okay, so let me now move to the labor chapter in TPP. And so the slide would be helpful to look at. You have on these columns different free trade agreements, started with NAFTA, going all the way to TPP, And then what you have here on this column are what are the substantive rights or standards, what are the dispute settlement provisions, and what are the remedies, so how enforceable these labor standards are in these different trade agreements. And what you can see here is a clear progression along these lines from NAFTA to TPP. So NAFTA included a labor side agreement, which basically require countries to fulfill their own domestic laws. TPP and previous agreements include internationally recognized labor standards as declared by the ILO Declaration on Fundamental Principles and Rights at Work, right? So the idea is there's a supranational standard that all countries can abide by on these basic rights. Freedom of what you have in there. Freedom of association, collective bargaining, prohibition on forced labor, prohibition on child labor, and elimination of discrimination. And then you have some of the additions here of TPP, which included maintaining acceptable conditions of work related to minimum wage, hours of work, and occupational safe and healthy. And also a requirement not to derogate from labor rights in special economic zones, and an obligation to discourage the importation of goods produced by forced labor. And then on dispute settlement, you have so NAFTA that started with a very timid dispute settlement provision that was sort of a separate provision from the main agreement, only for specific rights and with a monetary penalty that was basically regarded as really not enforceable. I mean, some of the scholars that wrote about it, and you had, for those students who are in the seminar, you had another paper written by Lance Kompa, who analyzed the NAFTA labor side agreement and pointed out some of the perhaps surprising advantages of the labor side agreement, which included some degree of transnational collaboration and also recognition of labor violations in Mexico, but also in the United States, and the possibility to use that mechanism as a way of shaming the governments that were not complying with their own domestic norms. But as future trade agreements progress, the dispute settlement became part of the main agreement. So now in TPP you have the labor provisions are subject to the main dispute settlement resolution, and you have, when it comes to remedies, the possibility of using trade sanctions as a stick to enforce those labor rights. So here you have a clear progression along these lines, starting from NAFTA all the way to TPP. And so why was this not a motive for enthusiasm and support if TPP had gotten all this and had actually moved even beyond the previous agreement, which had been the sort of model, which was the Peru-US agreement. And so TPP in that sense was supposed to be Peru plus. It added on to that agreement. And so some of the criticisms that were advanced by the representatives of the labor movement in the United States, which composed the Labor Advisory Group, which basically has a statutory obligation to advise the USTR, the US Trade Representative. So this Labor Advisory Group wrote a very critical report of TPP, including of the labor chapter. And also the AFL-CIO wrote very critical comments on it. They were very disappointed with what TPP had achieved. And so some of these criticisms, I'll go over them, were that even though it is true that for the first time TPP had required parties to adopt laws concerning acceptable conditions of work with respect to minimum wages, hours of work, occupational health and safety, it also determined that those obligations will be satisfied as determined by the parties. So it basically gave the parties a lot of leeway to determine what those would be. So in contrast to these 5 obligations that are reference to an international standard, those other are set by each country. And so therefore they thought they can set a very low bar and still be in compliance. It doesn't really have much substance. There was a weak protection on forced labor. So even though it's true that there's a requirement to not trade in goods that come from forced labor, the obligation to discourage trade in phase labor is so weak that a party could, and here they were basically mocking the provision, they say they could met that obligation by hanging a poster discouraging trade in goods. So there's really no clear benchmarks or language that could make this obligation enforceable or even very substantive. There were limited protection against derogations of labor rights, and it's also limited to export processing zones. This leaves unprotected the vast majority of workers in TPP countries. There's a problem of definitional clarity, and this is something that labor advocates have been pushing for a while, also in the previous trade agreements. They are arguing for, or they're pushing for moving from the declaration of the ILO, the 1998 declaration, to the conventions of the ILO that actually have these obligations and that have established more robust language that has been interpreted and they think could be actually used as better, well-established standards. And so in their view, the chapter has a lot of aspirational and vague language, language like may and endeavor to encourage, that is hortatory and fails to establish clear protections for workers in TPP countries. So in their view, this doesn't add much value after all. The TPP was touted and boasted as the gold standard of globalization and of labor chapters. They basically think it completely underwhelmed and it didn't really stood to that promise or stood up to that promise. And then finally, I want to just make a comment on the labor consistency plans. So the TPP had 3 labor consistency plans for Vietnam, Malaysia, and Brunei. So the 3 developing countries that were considered to be the ones with more problematic record on compliance of labor laws. And there, again, the labor advocates were in the US were very critical of this labor consistency plan because in their view, it lacked clear benchmarks and independent evaluations. And in addition to that, it also gave Vietnam a grace period of 5 years for the unionization of above the enterprise levels across industries or sectors. But when one looks at the labor consistency plan, it's actually in many ways quite remarkable. And so I just want to note 2 things. One is that it basically obliged Vietnam to break the monopoly of unionization by the official government-controlled union and allowed independent unions. And it actually bolstered that up with an ability to take union membership dues by these independent unions, that is to receive or collect these dues, the share of the 2% fee paid by the employers. And the other obligation is that it also allowed labor unions to request and receive technical assistance and training from any Vietnamese or international worker organization legally operating in Vietnam, which meant that NGOs, including NGOs from the United States, could actually participate, providing technical assistance. So the AFL-CIO has a labor solidarity office that actually has been quite active in other countries, including Mexico. And so this was an opportunity for them to actually participate in conjunction with independent grassroots unions in Vietnam. And Vietnam agreed to reform its labor law to fulfill these labor obligations, collective bargaining, freedom of association, and so on. And so, of course, I think that the labor advocates were right to point out that the labor consistency plan did not meet what would be foreseeable in an ideal world, but trade agreements are always compromises, and you know, thinking about this labor consistency plan in the context of Vietnam, a communist country with a tradition of a highly, tightly controlled, centralized union, these changes are quite remarkable. And so I think one needs to also understand some of the achievements. And I think, in my view, this is one of them. Now, again, this would need to be accompanied, and it doesn't mean that this will solve all problems at all. One of the insights of the labor advocates is that when you have more leverage to effect reform in a country, it's in the negotiating process. And so they were disappointed about the grace period because they thought that the U.S. was letting Vietnam off the hook in some of these aspects by granting a grace period. Nevertheless, I think that there are important aspects of the labor consistency plan that need to be recognized. All right, so now let me move to the second part of the presentation, thinking about other aspects of the trade agreement beyond the labor chapter. And here's where I think that the labor advocates really hit the mark, which is that in some way, I think that they realized that the insistence on labor chapters, even if they were well designed and had problems, and they pointed this out, there were a lot of problems of enforcement. Just recently, labor dispute was decided between the United States and Guatemala in the CAFTA trade agreement, and it took about 10 years for that case to actually be resolved, and the interpretation of that, of the labor provisions were so stringently interpreted that basically the tribunal, or the arbitral tribunal, found that even though there had been several labor violations in Guatemala, they couldn't be interpreted in a manner that affected trade between the parties. And I can talk a little bit more about that if you want in the Q&A. But basically, the point here is that even if you have more robust labor provisions, it's hard to enforce these trade agreements. They take a lot of time. And even if you manage to enforce those labor provisions by winning a case and being able to institute trade sanctions, there may be other areas of the trade agreements that might be much more relevant to workers. And so I think that they put that on the map in a way that was very forceful. That this idea that having a labor chapter can take care of the worry of the competitive disadvantage of workers in industrialized countries competing against workers in the developing world seems to be an illusion. Because even if you manage to end the worst forms of labor exploitation or of labor abuse, the labor cost differentials are still quite considerable. And so it seems like that's not really gonna make a difference for workers in the industrialized world. And so then what are other chapters that might be relevant in trade agreements that workers are considering important to focus on? And so I'd like to flag 4. One is the investment chapter. And so here the argument is that there is an asymmetry in the treatment of investors and in the treatment of workers that is tilting the balance in favor of capital against labor. And the investment chapters are giving considerable protections to investors. In fact, they're giving a standard of protection that is higher than anywhere else in trade agreements, because the non-discrimination obligation is national treatment, but they're treating foreign investors better than national investors, right? So states, national investors can can't have the protections that foreign investors have in these agreements. And they establish arbitral panels that bypass national courts. There's also a weak evidence of the relationship between these type of investment chapters and actual foreign investment. So there are countries that don't have foreign investment agreements and still have considerable investment flows. And so the empirical evidence is quite weak in the relationship between, or at least a causal link between these trade investment chapters and actual foreign investment. So they argue there's really little reason to have them. And more importantly, they also restrain the ability of states to regulate in a variety of domains, including health, environment, and labor. So there's a case that is pending by a company called Veolia, a French multinational utility company that sued the government of Egypt for a minimum wage law because it deemed that that had basically impacted its investment. And so you can, we don't know yet what the decision on that case will be, but you can see the concerns about the restriction on regulatory autonomy of states and in the way in which investment chapters might be putting corporate interests before public interest. Okay, so this has been a concern. I think one interesting thing to note is that some of these criticisms have been raised by developing countries before, but in the current global context, as industrialized countries have become recipients of investment flows by emerging economies, they're realizing what constraints they impose on their capacity to regulate. And so this was one of the main objections to TPP by many progressive actors in the United States. Okay, so rules of origin. So the rules that determine where a product originates from and establishes a threshold for the content of that a product has to have in order to be considered as originated in a country. So as countries give preferential treatment to goods from other countries, they have to make sure that those goods in fact come from the countries that they're granting preferences to. And so the rule of origins establish the criteria that will basically help countries make those determinations. And so you probably have heard about the debate on rules of origin now and the NAFTA negotiations. It turns out workers are very worried about this and want to increase the regional content of the goods that are considered to be part of the TPP, so that they don't have to compete against goods from other countries that could be leaked in the TPP. So in other words, here the idea is the more regional content a good has, or the higher the threshold is, the likelier the chances that they'll have a competitive advantage in the TPP against goods originating elsewhere. The chapter of government procurement, which basically is the expenditures of the state and the way the state buys supplies for different purposes. And here, let me just remark that for many countries, this is a big chunk of the economy. So the OECD, I think, calculates that public procurement is somewhere between 15 and 20% of GDP for their member countries. But so that's and it might be more in some countries. The last statistic I saw about the United States, its public expenditures were about 38% of the GDP. So you're talking about a considerable size of the economy. And here the argument of labor advocates is that government preferences, in other words, the ability of countries to favor its own domestic producers, could be part of a job creation program, and they also could be part of a stimulus package, particularly during recessions, just as we saw during the stimulus package after the financial crisis, with an inclusion of a Buy American provision in that package in the United States. And so, to the extent that countries give up that ability by allowing all other members to participate on equal footing with their own domestic producers, they lose that tool or that capacity. And finally, currency manipulation. And so here, they were making the argument that when countries have take measures to devalue their currency, they make their exports more competitive, and therefore hurt their trading partners. And so this has been a concern in the United States, particularly some years ago in the case of China and also Japan. And I think this is an ongoing debate. Some economists think that it isn't really that easy to identify what is a legitimate monetary policy and what isn't. And so what many policies may have an effect on the exchange rate. And so it's not easy to agree on what the criteria should be to determine who's a currency manipulator deliberately devaluing its currency for these purposes or not. But I think this is an interesting debate, but the labor advocates are pointing out this is something that greatly affects workers. So finally, let me move to the third part, talking about other international and domestic policy areas. So I recently organized a conference about the future of NAFTA at Georgetown, and it was interesting to see how often some policy makers and analysts would make the argument that if there have been negative effects of trade, the answer to those negative effects should lie at the domestic level. In other words, the international trade agreements and those rules aren't the place to remedy or change the effects that different groups at the domestic level are experiencing. And I'm really interested in challenging this perception, because I think that the answer lies at both levels, at the international and at the domestic level. And so one way to think about it is that this argument resonates with the argument that we should let the market do its work because what we're interested in is efficiency gains, and then think about distribution using tax and transfer mechanisms, right? So this is an argument that is commonly associated with the first law in economics movement, but there has been a lot of scholarship criticizing that position, actually making the argument that markets don't establish the conditions for its own operation, and that in fact there are many different ways to establish market rules that will produce different efficient scenarios with different distributional consequences. So in other words, the international rules here of the trade agreements establish what type of market, global market, we are creating, and that has distributive consequences at the domestic level. But those rules are just one possibility. There are other possibilities of those rules, other variations. And so I think that we need to think about both the international and the domestic rules. And here I'm thinking of the work that Danny Roderick, an economist at the Kennedy School of Government at Harvard, has done, precisely looking at how when you're looking at trade agreements that have already, with countries that have reduced their tariffs quite considerably, and you're looking at further liberalization, the efficiency gains of further reductions on tariffs might be actually quite tiny, but the distributional effects might be quite big. And so that as societies, we need to consider what those effects are and ask questions about what are the merits of those who are winning and whether that is palatable and to society, and whether we think those gains are legitimate, because the efficiency gains might actually be quite small and really not worth it. And so here basically the idea is to examine and scrutinize the international rules that are creating those effects. And some of them might be related, for example, to trade agreements like the ones I just mentioned before, but others have to do with, for example, tax incentives, the way in which the tax regimes of states have created this forum shopping and this race to the bottom in attracting corporations. And so maybe there is an important project there at the global level to try to prevent this type of competition. And then also, we might need to think about the current balance between capital and labor that has to do with the high mobility of capital and the relative immobility of labor. So rules of capital flows and of migration. And I think that those are also rules that have affected the balance of these factors of production. And so these are just examples of other rules that we could examine in other policy domains. And then finally, thinking about the domestic regulation, there's of course the idea that if we're unhappy about the effects that trade has had domestically, then we need to compensate the losers. But in my view, that argument is often too narrow. So in the United States, there's often the reference to trade adjustment assistance, a program that basically is designed to compensate workers that have been affected by trade. But one might take actually a much broader view about what are the kind of provisions that a country can introduce to make workers much more able to withstand the challenges of globalization and the risks that open markets entail, including provisions for health insurance, better education, perhaps basic income, wage and unemployment insurance. In other words, it seems odd to be to be thinking about this in this current political moment, but some scholars have actually pointed out that the countries that have been better able to take advantage of globalization and where open markets are more palatable are precisely the countries that have established social insurance provisions and welfare regimes that make those shocks more endurable and allow citizens and workers to be able to stand on their feet again when they are hit. And so this calls for a much broader agenda than just a narrow idea about how you compensate those losers who have been affected from trade. So that's the domestic aspect that I think we need to rethink as well. So let me just conclude with a question. Are labor chapters in trade agreement useless or hopeless? So I think that they provide a tool, but it's important to realize that it's just one tool in the inventory of regulatory mechanisms. They can be helpful, especially to developing countries, if they're local actors that are demanding it and that can use it for domestic reform. But I think that they played a role in an illusion of what they could accomplish that is clear now they really can't. And so let me just finish with an example of what I mean by this. One really interesting development during the TPP negotiations was that the government of Mexico agreed to a constitutional reform to change some of its labor institutions and labor provisions. So Mexico refused the US proposal to have a labor consistency plan because, according to their estimation, that would really perhaps diminish their status, and they didn't want to be compared with Vietnam or Brunei or Malaysia. But they agreed to a constitutional reform that actually changed the dispute settlement mechanisms. In Mexico, there's a board, it's called the Junta de Conciliación y Arbitraje, so the Conciliation and Arbitration Board, a tripartite, government, union, and employer board that settles disputes, labor disputes. And independent unions and civil society organizations have been for years demanding change because the boards are considered to be incredibly biased against independent unions, very pro-official unions, and very non-independent, very dependent on the executive. Also, the constitutional reform stands for that change. And equally important, there's now an independent institution that will be in charge of registering unions and of registering collective agreements, taking that away from the government, from the Secretary of Labor and Social Security. And so now what remains is the implementation law, which, again, labor advocates in Mexico are worried will undermine or change the original aspirations of this constitutional reform. But during the NAFTA renegotiation, these labor advocates could use the leverage they have to try to finish that work. And so one of the interesting legacies of TPP might have been, for Mexico, this reform that went completely under the radar, but was part of the pressures that the US brought in the negotiations. So again, it's not like the labor chapters are completely irrelevant, but I think that they're a tool that has to be understood in a much broader context, and there might be other provisions on trade agreements and other aspects of the global architecture that might be much more promising for workers in the global economy. So now let me respond, or do I do that later, to the students who wrote reactions?
I thought you were going to respond to Willie already.
Yeah, because I can anticipate Willie's comments, so.
You could always sort of first say what Willie will say and then respond.
Okay, so why don't I respond to the students after Willie's comments, and so I'll have to respond to both Willie and the students. All right, thank you.
It's wonderful to have Alvaro back in Austin, even for just a few days. And it's a wonderful job that he's done, taking stock of the labor chapters in trade agreements and situating their story in the broader context of labor and economic policy in the developing world on the one hand and the advanced economies on the other. Shining through the paper is Alvaro's thoughtfulness and nuance and synthetic powers, distilling an enormous body of literature so lucidly. And it's a pretty sober and restrained piece of work and spare. It's more about policy than it is about politics. And I think Alvaro may be cross with me for saying so, that although there are just intimations of bold, reimagining, there's something restrained as well about the kinds of reform ideas that in this paper at least he puts forward, which I imagine has something to do with the context for which he wrote the paper. But in any event, in very swift steps, I'm going to push him a bit, both to talk a little bit more about sort of politics and political economy, and a little bit more about what a sort of bolder reimagining of what the left is inclined to call fair trade policies might look like, partly in virtue of what Alvaro points out, that it's a remarkable moment we're in which we have Trump in the White House, partly at least by dint of his flashing critiques of TPP and American free trade policies on one hand, and so much of what he says, right, chimes with what the labor movement is saying, right, down to what they both saw as sort of one of the cardinal sins of our trading partners, namely currency manipulation, something about which Alvaro maybe wisely is agnostic about. It's beyond my pay grade. But in any case, it is a striking moment that in certain ways, from left to right, there is discontent in the center, right? An openness to revisiting the architecture of trade. So why not think boldly? So I confess to a certain puzzle, maybe because Alvaro has done his work so well. What is slightly puzzling to me is why the labor movement ever cared about the labor chapters of these trade agreements. So there are a few possibilities, and I'm curious whether Alvaro has sort of the background sort of insights and familiarity with what goes on in the labor movement and its apparatchiks to lead to this focus. In other words, why would they ever think, was it a matter, why would one ever think that bringing decent labor standards in the sense that these tools embody them to various developing countries as trading partners would make a palpable difference from the self-regarding point of view of American workers? Was it simply the idea that you would sharply diminish the comparative advantage of these countries by ratcheting up their labor standards? Was it instead a sort of more idealist motivation of international solidarity? We go out into the world to help build up free unions and so on. Or was it simply the notion that our leverage is here, and if we can, right, get some traction with excluding, right, companies or countries whose manufacturers flout whatever standards we've gotten, we will get those competitors out of the market. The greater damage they're doing may be in virtue of some other aspects of their situation and not their flouting labor standards. In other words, you've sort of persuaded us so well that labor standards, while they may be indispensable for the workers or would-be unions in Vietnam, may only make a marginal difference in terms of the American economy. So I'm curious what the political economy is, what's the motivation behind, if it's the case that until TPP, the AFL-CIO was so riveted on these chapters. Why? They're not dumb, and they surely, had insights about the other elements of the situation. So that's one question. By the same token, right, one may wonder whether Alvaro's of a mind that a labor chapter, right, in some future agreement, powered by some new political coalition here and elsewhere in the developed world, could actually have standards that had bite in the advanced capitalist countries as well as in the developing world. Is there a notion, I've simply plead ignorance about the extent to which the project is to build toward labor, and is it a good idea, right, to imagine labor chapters, since one is in the business now, as Alvaro suggests, of thinking about restoring symmetry between the sort of arbitral mechanisms that's available to investors as private actors in a trade regime, but not available to labor, the asymmetry that Alvaro mentioned. And here, I'm just slipping into the let's think big part of the commentary, and then I'll conclude. But one possible avenue for thinking large would be to think about labor chapters that actually had bite in, and maybe that's already afoot, but labor chapters that have bite in developed countries as well. Certainly, the US could use, right, labor reforms that would make sectoral bargaining of the kind that Vietnam has apparently acquiesced in available in the US, which doesn't mean in the real world that that would materialize. But if one is sort of thinking about which avenues to push on and where the incipient possibilities are, maybe that's worth thinking about, or maybe not, right? Maybe not. And finally, also in respect of crafting a sort of future trade agreement with, taking advantage of the changing political winds, are there ways to foster through the labor chapters and enforcement machinery? Who would have standing in these things, by the way? It's clear enough that the foreign investors with capital in the US or in Canada have standing. Would it be the workers' organizations in the country itself whose governments are not enforcing standards, or would it be, right, the labor organizations elsewhere in partner countries who would have standing to challenge, right, violations of the, and are there ways of imagining an architecture that would actually foster sort of practical solidarity, not just sort of a professional interest in building up labor chapters for Vietnam, but a practical solidarity that links workers' organizations across national lines? And then stepping even further back, I was struck that while Alvaro said surely there are both national and international dimensions to the problem of making right the injuries of free trade, where they fall among working classes in different countries, that there are international dimensions, and that as well as domestic ones, that much of the weight of this paper is on the domestic side when it comes to making right the situation of workers injured by trade. You rightly say, we need stronger job creation, we need stronger retraining, we need social insurance, we need basic income perhaps. In any event, a kind of medley of national policies. And so I'm inviting all of us, Alvaro, but also the rest of us, including the one economist in the room, to say, well, what would be the sort of basic principles of a fair trade sort of regime that doesn't need to be sold tomorrow to the sort of people who participate in international trade conversations in the world that is looking simply for incremental steps from these trade agreements? What are the sort of broader elements? How does a broader picture of fair trade reckon with sort of sustaining the comparative advantage of developing countries for what it does that is good for them, and dampening those advantages where they needlessly injure working people in the developed world? I confess, again, it's past my pay grade, and I've passed my time. But those are my questions for my comrade Alvaro.
Thank you very much. Really very easy questions. So let me, I really like the way you rephrased my paper, or reframed my paper, or characterized it, and your challenges too. I think these are questions that I'm struggling with and that I'm thinking about in this paper and in the ongoing research. I have to confess, I don't have ready-made answers for these challenges. I think they're really hitting the target and the difficulty of the current moment. So why did the labor movement ever care about labor chapters? I don't think there is a single answer to that, and I think you anticipated in some way the mix of reasons why they cared about it. I think they. So, and before I say that, your comments also made me think that maybe I need to go back to the paper and soften the narrative a little bit, because from your comments, I get the idea that it almost seems like they were, really excited about labor chapters all along until they arrived at TPP and realized, oh, this might not be a good project after all. And I think that was much more of a gradual process. I think that they genuinely thought that the labor chapter could be used to prevent what they called unfair trade or social dumping, and help. So on the one hand, and so that the phrase used here is to level the playing field, that the trade conditions would at least be fair, even recognizing that there are cost differentials, and so that in that sense, developing countries wouldn't have an unfair trade advantage. On the other hand, I think that there was also genuine international solidarity or interest in the fate of other workers. And you can see that in the work of the AFL-CIO Labor Solidarity Office, for instance, and in the way that actually led to transnational campaigns and collaborations with NAFTA and in other agreements. And so I think that also plays an element. And then the other part of it, which you then asked in the second question, is that I also heard the argument by some labor activists that they were interested in the labor chapters of trade agreements because it gave them another lever domestically. So once the United States had signed up to free trade agreements actually recognizing international labor standards, they could also use that in conjunction with unions abroad to pressure the United States government and employers here. And so I think in some ways they also understood the possibility of the triangulation. So I think it's a mix of these explanations. I don't have a clean-cut answer. I don't know if one of these was the dominant one, but I think that there was a confluence of this. In terms of your question about enforcement, so how can we do this if we were to, think ambitiously? I think that I don't have a workout sort of, and it would be good to actually think about concrete proposals of whether you would want to give standing to labor organizations in a dispute settlement that would emulate the one that investors have. And so Lance Compa, actually, the author of the other paper you had for today, wrote a piece in The Nation, precisely arguing for that what if we were to balance the equation by giving labor organizations and consumer organizations the same standing that we currently give to investors. And the other possibility would actually be to reduce the leverage that investors currently have by taking away those protections or taking away their standing as private claimants and making them go through the government just in the way that we make labor organizations do. So I think there are different ways to rebalance that equation, and we need to explore several alternatives in that regard. Another example of that was the carve-out for tobacco control that was actually introduced as a result of the enormous concern with the way in which tobacco companies had pressured governments and resisted some of their regulatory attempts. And so there was an explicit carve-out saying that the chapter didn't apply to regulation to control tobacco. And that's just an example of what can be done. That is that there is a concern and that in fact those protections can be limited. I will end with an argument that is not going to satisfy you, but that in my view countries have to think, and here I'm thinking particularly of developing countries and the case of Mexico, that, I mean, this is influenced by my view of NAFTA, but that, even if you were to design a wonderful, labor chapter, what has happened with this trade agreement is that it has basically become the development policy of the country, that trade agreements stand in and the liberalization agenda stand in for the development policy of the country, and that, in my view, the most successful examples of growth and of welfare for workers have been the countries that have managed to grow, and they have done that with a variety of different industrial policies. And so that we need to think more broader than just labor chapters to think about how we might be able to create jobs and create better paid jobs. But that's a general answer that I think needs to be connected to concrete alternatives for how we regulate the labor, the potential labor standards and enforcement that you were asking me to think further about. So let me now respond briefly to the students that wrote reaction papers. So Francis, where are you? Over there. So one of your, thank you to the students who wrote, Francis, Nicholas, and Matt, for your comments. I mean, I'm picking the comments or critiques that seem most salient. And so Francis, I think your main concern is that this seems too complex, that there are too many issues, basically. So it turns out we not only have to think about the labor chapter, but about other chapters in the trade agreements, and not only that, but also, maybe other international rules, and then at the domestic level, there's a bunch of different policies. And so I think that, yeah, you're right. I think that's the world we live in, and I think it's an important realization to think about a broader map of what might be affecting the current situation of workers and how we might be able to intervene to improve their conditions. And so, yes, I think that, it would be easier if we focus, say, in labor chapters and thought that could bring about change. But part of what this paper advances is the idea that might be just too narrow and too limiting, and that we might need to think much broader than that. Now, I think depending on the context that you're focusing on and the country that you're looking at, some of these areas might be more relevant than others. And so in some ways, this is a map of the perhaps more promising avenues for intervention. But of course, resources are limited, and you need to pick your battles and choose, which areas you think are more promising. So Nicolas, great. Your comment on the difficulty to enforce labor chapters, and I think you basically introduced the idea or the suggestion of a supranational arbitration court that could be transparent and democratic. I'm generally skeptical about that idea, and I think that it would actually be better to. It depends on exactly what you mean by a transnational arbitration court, but I think the model of investment tribunals, for example, have not been very satisfactory. I mean, apart from the criticisms that I raised, particularly in the case of arbitration, there is a potential conflict of interest in the sense that there's this basically pool of arbitrators that are also litigants and represent parties in these disputes. And so I think that one model that is emerging, that, for example, Canada and Europe are negotiating in their trade agreement, in CETA, is a permanent court, like the one that exists, say, in the WTO with the appellate body, right? So it's supranational, but it's not an arbitral panels, it's more a permanent body that actually has designated individuals as judges for a number of years that are not acting on behalf of parties when they're not acting as arbitrators. And so I think that could also be, useful. But I also think there is an argument for thinking back about the mechanisms that already exist in countries' institutional setups, meaning courts, that have been for many countries quite expensive to establish, and they've taken lots of time to actually put in place. Many of them work well, but they are balancing different considerations, right? And so the impulse to try to go to an arbitration court is to bypass the national courts, often, to be more expeditious, but also I think that we lose something by doing that. So I'm generally not a big fan of these supranational arbitrations. I guess, again, it depends on what context, and I'm happy to think more about them, but you'll have to give me a good example of why this is a good idea and not just an excuse to bypass the national courts in the interests of the specific stakeholders that you have in mind. And then Matt, is a trade agreement better than no trade agreement? So it seems like a really simple question, and I think it's very good. And so I've gotten this question now in the context of NAFTA, the NAFTA renegotiation, right? Because when you look at the effects of NAFTA, it turns out that while investment increased dramatically, so thinking about the case of Mexico, and trade volumes also increased dramatically. When you look at the initial objectives of NAFTA, which had to do with raising living standards, as the president of Mexico at that time put it, Mexico wanted to stop exporting workers and wanted to create jobs in the country, right? And so in that regard, the treaty has been quite disappointing because if you look at the growth rates of Mexico, it's one of the worst growth rates in Latin America, around 1.3% average per year. The poverty levels are actually almost at the same level that they were in 1994 when NAFTA entered into force. And so, I think that the country hasn't gotten what it expected from the treaty. It was definitely overpromised. And so the question now, again, going back to Willy's observation about the moment and can we think about reimagining this more boldly, I think that we need to reevaluate what the treaty is doing and in what way it's being used as an engine for economic growth. And there I think that unfortunately there's not much thinking, on this front. And so I'm not an advocate for ending NAFTA. I think that the results have been very uneven. There have been certain sectors and companies that have benefited greatly. Others have lost. And one of the things that NAFTA has created is a huge cleavage between the successful vanguard companies and sectors that are exporting, financing themselves in the international markets, and the companies producing mostly for the internal market. So the links between these sectors have been quite severed. as a result of liberalization. And that's partly expected because, as a company, you get your inputs from wherever you can buy them, cheaply. But I don't think that the government had policies that try to continue the creation of chains within the country or had any remedies to, counter this phenomena. And so I think that it's not an argument against free trade in itself, it's an argument for the type of liberalization that has proceeded. And the government of Mexico at this point is too busy trying to demonstrate to the United States that the agreement has also been beneficial for the US, given the narrative of the Trump administration, but it's has kind of forgotten to reevaluate what NAFTA has done for the country and how it could use it better, in my view.
All right. Thanks to both of you and for the generous response and for not making the students ask their questions. But why don't we take like two more from the class if they're there now? I see now Nick was supposed to respond.
Not there.
Oh, let me just get a sense of the people who want to ask questions, because great, okay, so why don't we, you can respond, Nicholas, and then, or asking you, and then Murat, and then we'll move outside and go on that post. Okay, great.
Can I pass around the mic for the recording?
Thank you for the talk and the response to my ideas. So my very gutsy explanation for the opposition to those labor standards by the workers themselves is that it is inevitable for the industrialized countries that low skilled jobs will get lost. And I think on the aggregate aspect, those jobs will be replaced with maybe better paid jobs. But what I think is that if you look on the individual level, that you also have to look at the aspect of training and education. So especially for people who are a little bit older, it will get very hard to change jobs, to get retrained or to settle in different sectors. So I think it's more the difference between the aggregate and the individual level that plays a huge role in this opposition against free trade.
Okay, so I think the opposition is fueled by the concern of the effects that workers have experienced. But it's not only low-skilled jobs. In fact, one of the main worries has been manufacturing, which entail, high skills, and many of these jobs were actually very well paid. And so then, when you lose those jobs, you take a huge hit on your wage if you manage to find another job. And so I think that's been one of the huge challenges. Now, of course, there's a debate about to what extent you can attribute the loss of manufacturing to these type of trade agreements as opposed to technology, innovation, and what has actually been the effect of trade agreements on loss of manufacturing jobs. But there seems to be what some scholars have called a secular decline in manufacturing in the industrialized world, for which the programs that you're referring to, training and education, and also the ability of workers to be able to not depend on a specific job for their health insurance and would be really key. So this type of other social insurance provisions that I was talking about, I think would be really needed.
Hi. First, thank you for coming here for the wonderful talk. I wanted to ask about the, complaints about the investor trade dispute section of the TPP chapter. It seems like some of the concerns that countries have about this chapter might be legitimate, and in just thinking about the example of South Africa and how when they tried to implement domestic Black economic empowerment initiatives, some of the parties to the bilateral investment treaties started suits indicating, loss of wealth and, harm from violations of these contracts. So how do you think, are there ways of incorporating for potentially legitimate, domestic legislation like you mentioned, where countries, whether it's for Black economic empowerment or health and safety or certain sectors, are there ways to make limited carve-outs that you think might, limit the impact of some of these investor trade dispute, the transnational agreements?
I think so, yeah. And I think that it would be good to think more broadly than limited carve-outs like the tobacco control litigation. And the idea would be to think at the level of substantive rights. How are we protecting investors, foreign investors, vis-a-vis domestic investors? So maybe we should give them national treatment and just make sure that we don't discriminate against them when compared to national investors. And then also establish, if we want to continue with transnational or supranational tribunals, make them look at the example of the Canada-EU agreement. And there are other suggestions floating around where, investors don't have potential conflicts of interest, which are actually quite considerable, right? So it's a small clique of lawyers, all of which know each other very well and have different kinds of incentives. Not that all of them will actually be biased in favor of investors against states. There are others that have a reputation for siding with states, but basically it would be better to have a more permanent body that could be also scrutinized and maybe renewed if the members think that they've done a good job. But so I would say there's work to do both at the substantive provisions and then at the design of the bodies that adjudicate these questions. But another possibility would be to get rid of these transnational courts and subject investors to the national courts, just as other parties have to do, or subject them to the regular form of dispute settlement in which they have to be represented by their governments, just like in the WTO, without giving them a private right of action. So I think there are several possibilities. I don't know exactly which one would be the most promising, but I think the time is ripe for rethinking the effects that this protection on to investors has had in many countries.
Once the U.S. exited TPP, did the emphasis on the labor content of the agreement decrease, stay the same, or increase?
I think that what happened after the U.S. left the TPP is that interest in the TPP in general decreased. And it's only now that so for example, other agreements being negotiated, like the NAFTA renegotiation, TPP becomes relevant because there are rules or chapters that are being drawn or borrowed for their renegotiation. And so there, what I've seen is, a renewed interest in the labor chapter, thinking we should import it to NAFTA. And since the US and Mexico were parties to the TPP, they probably would agree to this. And so I think that in that sense, it becomes relevant again. Dan?
Oh, you have a question? Okay, and then
Yes.
Jamie is offered to take a stab at Lloyd's question.
Okay. All right. Okay. So I'm intrigued by your kind of starting point that there seems to be some overlap between a sort of economic nationalist critique from the right and whatever you call the critique from the left, progressive labor protective critique from the left or whatever, and that kind of creates an opportunity to do something. But it seems like we've sort of, because of this, we've shifted the focus, in the classic elephant graph that
Yeah.
Branko Milanovic does. So
Yeah.
we've shifted all the focus of concern to that dip at the elephant's trunk, I guess, and we've kind of forgotten about the people in the elephant's tail in a way, which was sort of the traditional concern, I think, for people who had critiques of free trade and free trade agreements and so on, right? And so one question is, have we shifted the focus of our concerns so that now we're mostly interested in protecting workers in the developed world, right, and not so much worried about the people in the tail of the elephant. And this, I think, is a related question. That if we are worried about the workers in the developed world, it seems like there's two models, and Willie alluded to this a little bit. One is we could, well, so or at least the traditional model of working through free trade agreements and including labor standards in them was to sort of eliminate labor costs, at least in part, as the advantage of engaging in free trade by creating some sort of global standard, right? And hoping that you can create, uniform standards across the entire world that would be labor protective in some way. And the alternative model would be what Willie was suggesting earlier. Maybe the right place to protect is at the domestic level, in which you preserve the sort of relative advantage of low-income countries by keeping labor costs as one of the drivers of trade, but you protect workers in the developed world through social insurance programs, retraining, and all that sort of thing. And so I guess the question is, which of those two models do you think is better? Which one more aligns with the sort of economic nationalist? Which one would do better at addressing our traditional concern, which was not just for the workers in the head of the elephant, but also for the others, right? Should we be really shooting for global standards that protect everybody and create a sort of global standard, or should we be worried more at the domestic level at protecting workers who are displaced by trade and letting the workers in the developed world be helped by their own governments or by the market or whatever?
Yeah, I like your observation that there seems to be a shift in focus, and I think that you're right. And so part of the response is, well, let's take seriously these challenges to workers in the developed world, but also let's take this opportunity now that rich countries are willing to rethink that model, a model that they've pushed quite strongly before. And so I think that that's what presents an opportunity, but your point is well taken. Let's just not forget this other dimension, which was really important, which is, workers in the developing world. And so there, I don't know that, I don't know that you had to choose one of these models, because I think that I'm all for, and I understand the potential importance of international standards. So this project, right? The idea that you want to prevent a race to the bottom and prevent a collective action problem of, ever lower standards in the developing world, or at least incentivizing those. And so I think to the extent that this could help that project, yes, let's continue with that. At the end, I think that the successful examples of countries that have managed to increase the lot of their workers for the developing world has to do with growth and domestic policies, I would say. And I think, I would dare to say that China is an example of that, right? That doesn't mean that there aren't conditions of work that need to be addressed, and that there's still, a lot of concern about some of those conditions, but the progression for the condition of work in China has improved quite a bit, and it also shows that I think the strategy wasn't predicated long term on a strategy of using cheap labor. That there was a lot more going on in terms of, industrial policy and taking advantage of the way they integrated with the global economy. And so I think that to me is a more promising avenue for developing countries. So yeah, while you were talking, I was reminded, let me see if I can relate to it, but when I visited the WTO in Geneva with my class when I was teaching in London for a year, it was amazing to see that building. It's a beautiful building next to the river. It used to be the ILO building, and it has these incredible murals of industrial workers. In the rooms where the negotiators sit, and some of the disputes or the hearings take place, and it was just an incredible cognitive dissonance between sort of the relevance of labor, to have a building in Geneva with all these, plaques of international confederations of workers, and the role that they played in the global architecture at the beginning of the 20th century as the ILO, it was founded as part of the Treaty of Versailles and so forth, right? And so I don't know that the ILO had exactly, I think in some ways, that project, the idea of regulating for workers at the international level, perhaps preventing also, race to the bottoms and so forth. But a lot of it was informed by the domestic welfare states that countries undertook. And so I don't know that it's possible to return to that world exactly. In fact, I'm sure it isn't. But so the question would be, how do we reimagine a prominent role for workers and their input in the global architecture? I think we're far from that. And yeah, I don't know the answer. I think that trade agreements could play some role, but a lot will have to be done at the domestic level as well.
Willie made a somewhat sly allusion to the only economist in the room. If there is another one, I'm happy to yield the microphone. But the question that he asked was, what are essentially the elements of a fair trade regime, and what is the role of labor standards in such a regime? And that forced me to spend some time thinking hard before I accepted the microphone. But I'd like to just put an idea in front of you and ask for your reaction to it. And the thought that I had is that if you look at that list and you implemented every detail of the freedoms and rights that are listed there in any specific developing country or in all of them taken together, it wouldn't make any material difference to the trade regime, to the trade balance. It wouldn't make any material difference to the competitiveness of the developing country industries. Why is that? Because in every country, the most advanced industries with the best standards, generally speaking, are the ones that export. And the ones where these rights and requirements are the most abused and the most needed are in industries like, well, first of all, agriculture, but also, think about coal in China or the fireworks sector, where occupational safety and health is just appalling. That's not the case for the companies which are engaged in mass production for Western markets. Although they may have their own problems, they are nevertheless modern enterprises which have to operate to high standards of efficiency and can't afford to have the same kind of abusive environment that you would have in a primitive industry that doesn't export. And I think that's generally true at different levels of development for different countries. So you're driven to the conclusion that the problem that troubles labor in the advanced countries is trade itself. And that problem can't be resolved so long as there's a hierarchy of living standards and currency valuations and so forth, which gives the advanced countries an enormous purchasing power over the output of the whole world. And so at that point, it becomes, I mean, it comes back to the conclusion that you have to have and pursue a much more imaginative and broader role of, let's say, for social insurance, but policies like a job guarantee, regional redevelopment policies. And these are not going to solve the individual versus aggregate problem that you raised a few minutes ago, but they would at least give communities a sense that they were not being abandoned and that they were being renovated, you know, in due course following the intrusions of trade. If you want to have trade at all. If you don't want to have trade, you're still going to have that problem internally in large countries, because within the free trade region of the United States, industries are going to move. But then you're going to have the problem that you're not taking advantage of the living standards that are available from being able to buy advanced goods at very low prices from the best sources of supply. So I don't know that there is an answer to Willie's question, but it does seem to me that it's worth pointing out that these are really two issues that are barely in connection with each other. These are very good things, but where they would really bite is on sectors that aren't going to be exporting to the advanced world very much anyway. That's where the most important effect would be.
Yeah, thank you. I think that's generally right, and I don't disagree with your comment. I think there are, and perhaps this is at the margins, but we hear, you know, when we look at, say, reports of several organizations, there are cases of labor exploitation that wouldn't fit this, that wouldn't match these rights, and you know, we've seen some cases in Mexican maquiladoras, or in, you know, in Bangladesh, the Rana Plaza incident, in China with, you know, Foxconn. And so I think that, you know, perhaps is less generalizable, but I think that it is true, your observation that the ones that are competing in the global market are usually the sectors where the standards are better if you compare them to the domestic market.
They have to be, or they wouldn't attract the
Yes.
workers
Yes.
to begin with. It would be a compulsory labor situation, which it
Which
manifests.
sometimes happens, but
Sometimes
yes.
hasn't, but
Yeah.
happens. But by and large, it isn't
Yeah.
the case.
Yeah, I think that's right. And so the question is, how can, or is there room for linking in the developing world these to those workers in, you know, in the domestic market, in services sectors and so forth, to these standards? And one possible way is that once you implement these standards, if you make them enforceable, there might be spillover effects to these other sectors in the developing world. But your point about the developed world, I think it's really prescient that, you know, this might not do much for them, and that in fact you need these domestic measures to make workers be able to compete and withstand the challenges and the disruption of free trade. What I would observe is that the liberalization agenda almost happened in tandem with the dismantling of some of these social provisions in the developed world, right? With, you know, because it was accompanied by a deregulatory agenda domestically as well. And so I think that in some ways the work is to reimagine what that could be domestically.
You know, and maybe to point out that the anger directed to economic decay has been misdirected at the trading environment when it should have been directed at the macro policies and the anti-labor policies that actually preceded the opening of trade. It goes back in the United States to the early 1980s, which is before these issues were really as salient as they are. Just as a quick anecdote, when I was working with the State Planning Commission in China, I brought Michael Reich to write a paper on the role of free trade unions. And eventually, I don't know what the connection is, but eventually the People's Assembly passed a union law. It was lobbied against aggressively by guess which organization? The American Chamber of Commerce in China.
Yes,
Yeah.
yes, yes. And sorry, and just to follow up on that, it also coincides with a decrease in tax rates domestically, right? And so basically, at the moment where you need more resources to put in place social insurance provisions and compensate, you have actually less because you're giving up on your ability to tax and transfer.
Thanks. In some ways, I think this is a follow-up on Dan's question, but maybe picking up on some of the other threads in the room. And I'll ask you a very broad question and then something a little bit more specific. So, I mean, the broad question is really, who are you trying to convince with the paper? So who's the audience? And to be more, to add some specificity to it and suggest some that I hear, it seems like the paper is written to labor. At one level, it seems like it's written to people who are really focused on labor side agreements and saying, or who care about workers and haven't really thought about trade, and saying, and when you look at trade, you have to look at much more than the labor side agreements. But then the paper shows us, and as you said, the AFL-CIO actually kind of got it right by doing that. So then, I guess to connect it to Dan's question a bit, and even to Jamie's in terms of thinking about workers who aren't represented by thinking about free trade, there is, so I also had this sense, I thought, one of the things I really like about the presentation you made, it's not as much in the paper, but I think you could do more, is that you were bringing the perspective from at least a developing country, from Mexico, and you were bringing it in, you brought it in the context of NAFTA, but also really in the context of economic development. And so I think sometimes you're talking to states and you're representing the global south through development and sometimes even growth, or growth as the form of development that at times I hear you, or growth being the most important issue around development. You just said it a moment ago. But I didn't hear, so the Global South comes in that way, but not necessarily, I think, with that in the discourse, workers are sometimes subsumed, right? So if we get better development policies, then workers are going to be better off. And when we think about developing economies, that's the way we think about it. And then maybe when we think about advanced economies, we're thinking more about not development, or at least your focus isn't so much on development economy, it's or development, but it's more policy, but it's more on workers' rights. So I'm just kind of thinking, what would the paper look like if you could bring in more worker voices than the AFL-CIO? And surely, I mean, you do it a little bit with Vietnam and those side agreements, or you suggest that NGOs were favorable, or that the workers or the unions in Mexico were behind the constitutional reform, some parts of it. So it's not that it's totally absent, but it's kind of more as a side effect, really, of what was happening in the negotiations than something more intended when you talk about workers elsewhere. So, I mean, it's partly, so it's already, and going to the question, back to the question then, right? If you're trying to convince labor rights advocates in the global north of the need to look at other parts of labor agreements than that the AFL-CIO was looking at, or to think beyond, or to get on board with the AFL-CIO? Are you pushing for an international kind of solidarity that would get workers, to the extent that they're organized elsewhere, also focused on the other parts of the trade agreements? Could there be more solidarity in that capacity? That's easier, I think, when you're talking about negotiating something like NAFTA than the TPP with all the countries. So who do you want? Who's this aimed at?
Yeah. Okay. So, yeah, I think you've identified perhaps an ambition to talk to many different audiences, and that might basically dilute the message, and so I think that I have in mind both labor activists in the U.S. and Mexico on the one hand, and in the other, yes, governments or states, and that relates partly to my other research projects, one of which has been to think about the way in which trade has constrained the ability of states to undertake industrial policy measures that countries that experience successful development paths, I'm thinking particularly of the East Asian tigers, undertook. And so this is a debate that I'm really interested in, where I have that I have written about, and so in some ways it connects back to what extent not trade in itself, but the kind of trade agenda that has become dominant, encapsulated in treaties like this, has basically hoodwinked some states in thinking that this is a development strategy and that they will grow if they follow this recipe, right? And so part of my research has actually been focused on trying to dispel that idea, and also thinking how countries might act, particularly developing countries, might act more strategically to open space for themselves, even in the current scenario. This was basically the paper about the WTO, right? And so in some ways, that there's echoes of that interest in this paper again. And so I would say those are the audiences. And I think that the point that I'll rescue from your questions is that the assumption that once a country embarks on a development policy that is successful in terms of growth, that will take care of, workers' well-being, is a problematic assumption, and that therefore you also need to think about, how workers are faring, what are the types of policies that those countries are undertaking. There could be really, there could be workers that are hurt in that process as well. And so I think that, that assumption needs to be more explicit and also justified. And I need to think about, examples and the policies that could ensure better distribution of those resources once a country grows. But I think those are the audiences that I have in mind, and it's a critique to this, I would say, to your camp of human rights as labor rights. The idea that if we focus on these rights and we made them part of trade agreements, we will actually get a lot of traction, and there's been so much effort and so much energy devoted to this agenda that I think that perhaps we've lost the way, and it would be a good idea to rethink it.
I won't claim that camp. All right. Unless
This was just a clarifying question. When you talk about the criticisms that were lobbied at the TPP, were those also valid of things that were left out of the NAFTA side accord? Or what, my question basically is, was there any material sort of regressiveness about what was left out of TPP versus what was already excluded from? I know it included more countries, but I'm just curious in the case of the NAFTA labor side accord.
I'm sorry, say a little bit more, because I'm not sure I fully
The
understand.
criticisms about what was left out of TPP,
Yeah.
was there any material difference between the types of things that were excluded from the NAFTA labor side accord? I understand that there are more countries involved, but because from there it looks like there's a lot more protections and enforcement mechanisms.
TPP.
Correct.
Yeah.
But it's reading it sort of gave me this impression that maybe there were these loopholes that were noticeably different from other labor side accords.
In TPP.
Mm-hmm.
No, I mean, I think that the TPP, I mean, there were other things that the labor movement wanted that didn't make it to the TPP. So, for instance, one really interesting development was this idea of parties shall discourage the importation of goods produced by forced labor. So basically, this could be really powerful, the idea that all countries of this trade agreement will not import trades that goods that have inputs produced with forced labor. Doesn't matter where they come from. And that was definitely a new substantive provision. But the problem is that the way in which it is phrased, it really waters it down and doesn't make it really valuable, because it doesn't countries can take actions to discourage it, but it's not a full-blown prohibition. And so I think that part of what happened was that because NAFTA was just a labor side agreement, the labor and environmental labor side agreements, partly what this created, as you can see here, was a sense that, okay, you needed to build on that NAFTA was just a first attempt, and there were many other free trade agreements, and so that you could actually improve on what was previously negotiated, and that once you did that, you would get much better results. And I think we're at a moment where there's the realization that, in fact, probably not, and so we need to think about other avenues.
Thank you very much.
Thank you.